Good morning, everybody. Hello, my name is Councillor Finnegan. Just to let you know, we're not expecting any fire notices this morning. I think we're working again. Thank you. We'll try again. Good morning. My name is Victoria Finnegan, Councillor Finnegan, and I'll be chairing this morning. Just to let you know, we're not expecting a fire alarm this morning. So if you do hear a fire alarm, there's exits at the back of the chamber, and the central meeting point is outside the Lindcross pub in the centre town. Please make sure your phones are on silent mode or turned off. Thank you very much. And to use the microphone, as we've been seeing this morning, you press the button on the side, and please remember to turn it off after you finish speaking. Thank you. Okay, so just to let you know, we had an election of chairman this morning, and I was elected chair of the subcommittee today. Point 2 on the agenda is the minutes. Are we all in agreement of the minutes held on the 31st of July 25?
Agreed.
Agreed. Thank you. I take that as agreement of those minutes. Thank you. Agenda item number 3 is declarations of interest. Please, can any members let me know if they have any declarations of interest that they would like to make me aware of this morning? No declarations of interest. Thank you very much. Okay, so agenda item number 4 on our packs today is the application for review of premises licence, Turquoise 4 Periods Place, Horsham, RH12 1EH, on pages from 11 on your pack. I would like to just introduce this meeting. So really my job as chair today is to ensure that everybody has had an opportunity to ask questions and explain themselves today. So I really want to make sure it's quite a formal setting, but to make sure that everybody has had that opportunity to ask the questions that they want to today. I'm going to go round and make sure everyone introduces themselves before we start the meeting officially. So, right, so let's start with the desk up here. First of all, as I said, my name is Councillor Finnegan, and to my right.
John Trollope, I'm a councillor represent for the Billingshurst ward for Horsham City Council.
I'm Dennis Livingstone, a councillor for Nuthurst and Lower Beeding ward.
I'm Alison Bruce, I'm legal advisor for the council.
I'm Lewis Holmes, I'm a legal officer and I'm here to observe today.
Melissa Stallard, Democratic Services Officer.
And Liz Fennick, Democratic Services Officer.
And then if we go down to licences, thank you.
Charlene Ellis, Principal Licensing Officer, Horsham District Council.
And Duncan Williams, Licensing Officer, Horsham District Council.
Sevdet Mutlu, Premises Licence Holder.
My name's Frank Fender. I'm representing the premises licence holder this morning, Chair. Thank you.
Alex Romano, representing the Home Office. I'm a licensing compliance officer.
Thank you very much. So we're going to start the proceedings where we're going to hear reports, and then we're going to have a chance to ask questions. So that's going to start with the sort of licensing officer, and then we'll move to the applicant and the premises Turquoise, the licence holder. We don't have any other responsible authorities here this morning, and then we'll go to closing statements when each party will have an opportunity to make a closing statement. We will then go off, the councillors will go off and have deliberations, and then come back with a decision, hopefully today. Okay. Thank you. Yes, just a good point raised to me. If you do have any questions, please can you raise the questions through myself as chair. Thank you very much.
Good morning, everyone. Good morning, Chair. The licensing subcommittee will have seen the full report and exhibits relating to the premises, to the review of the premises license application put before them. The premises known as Turquoise is subject to this review hearing following concerns raised by the Home Office Immigration Enforcement Licensing Compliance Team in their capacity of responsible authority. A full copy of the review application is attached at Appendix 2 of the report. The site currently benefits from a premises license for the activity of selling alcohol. This was originally granted in July 2022 and is attached in full at the Appendix 1. The current premises license holder and the DPS in day-to-day control of the premises is Mr. Sedvet Metlu. The agenda is concise in its detail, so I will give you a brief executive summary of the review grounds before the applicant and representatives expand in further detail. The Home Office initiated an investigation into the employment practices of the premises after intelligence was received in respect of illegal workers at the site. In January this year, an enforcement visit was carried out. During this visit, officers encountered one employee who was identified as an immigration offender. During an interview with Derya Erdogan, the front of house manager at the time of the visit, she confirmed that she had conducted right-to-work checks on the worker by viewing their work permit, but had not verified his immigration statement. For additional information, on the 2nd of April 2025, the Home Office made a referral to the Civil Penalty Compliance Team in relation to illegal working, or to the illegal working. A civil penalty was issued to Weybridge Temple Limited for £40,000 on this same date. Weybridge Temple Limited is listed as the liable party for this civil penalty. Linked individuals, Sedvet Metlu, served as a director from the 22nd of March 2024 until his resignation in the 25th of September 2024. And Derya Erdogan held the role from the 25th of September 2024 to the 1st of May 2025. To the best of my knowledge, to date, no payment has been received and the appeal rights were exhausted on the 4th of May 2025. Due to the immigration offence identified, the Home Office state that the licensing objectives which underpin the wider Licensing Act 2023 have not been effectively promoted in respect of the prevention of crime and disorder. The Section 182 statutory guidance that sits alongside the Licensing Act 2023 is clear that the objective of the prevention of crime includes the prevention of immigration crime by allowing illegal workers in licensed premises. See sections 2.3, 2.5, 2.6, 8.6 and 10.10. Section 11.28 of the same guidance states that where reviews arise and the licensing authority determines that the prevention of crime objective is being undermined through the premises being used to further crimes, it is expected that revocation of the license, even in the first instance, should be seriously considered. For additional information, the site has also benefited from an announced full inspection by the licensing service on the 22nd of October 2025. See attached in appendices 6 and 7. Recent right-to-work checks carried out the premises for current staff can be seen at Appendix 8. During the consultation period, the application received 2 representations in support of the review. These were from Sussex Police, attached in Appendix 4, Den Neighbourhood Council, attached to Appendix 5. In conclusion, The overall outcome is for the subcommittee to determine the application by taking steps as it considers appropriate for the promotion of the licensing objectives, having both regard to the review application and any representation received and heard today. The applicant, the Home Office Immigration Enforcement Licensing Compliance Team, has suggested revocation as a suitable outcome. Appropriate considerations for action are outlined in point 4, page 16, under the heading Next Steps. Thank you.
Thank you very much for that report. Please can I ask now if the applicant or the licence holder has any questions that they would like to ask of the licensing officer?
No questions, thank you, Chair.
Thank you. Any questions?
No questions, thank you.
Thank you. Can I ask if there's any members up here who would like to ask any questions following that report?
Appendix 8 is it's recent applications. It's presented in November this year. Have those people been working engaged prior to those applications being put in?
That I'm unaware of. These were supplied when the pack was being put together in November.
Can I just say, Councillor Livingston, that might be a question that we could direct towards the Home Office.
We could ask Mr. Fender, I think.
Do the licence holder wish to respond to that?
Yeah, some of those on the additional list, Councillor, were still in employment between the time of this visit and the time of November. I will clarify the reason why all of those documents are dated November when I have the opportunity to present the case on behalf of the licence holder.
Okay, thank you.
Thank you. Any other questions from here? Councillor Trollope.
Thank you to the licensing officer. Are you aware of any particular pattern with this company? Is this the first time this has happened, or are you aware of any other information that is it not relevant? Sorry, I withdraw.
Thank you. I don't think it's relevant at the moment. Thank you very much, Councillor Trollope. Okay. Okay, we'll move on from that report then. Thank you very much. And now if we move on to the licence holder, would you like to provide us with your case, please? Thank you very much.
Yes, certainly. Thank you, Chair. Thank you, councillors. I'd like to start by
Just a point of order, actually. I think we're going to go to the Home Office to present next. Thank you very much.
Thank you. Good morning, Chair and Committee. I would first like to confirm that all the committee members have had the time to read the submission pack. I don't propose to read through the full pack, but I will make a few key points before I summarise the case. The ability to work illegally is a key driver of illegal migration. It encourages people to break the UK's immigration laws, and it provides the practical means for migrants to remain unlawfully in the UK. It also encourages people to take risks in trying to enter the UK illegally by putting their lives in the hands of unscrupulous people smugglers, and leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules and undercutting legitimate businesses that are. It also negatively impacts on the wages of lawful workers and can be linked to other labour market abuse, such as tax evasion, breach of the national minimum wage, and exploitative working conditions. Employing illegal workers undermines the licensing objectives, specifically the prevention of crime and disorder. Immigration enforcement do not just drive around looking for businesses to target. We are intelligence-led, and there have to be significant concerns for us to action incoming intelligence. We do not routinely seek a licence review, but we do so in selected cases where we have heightened concerns. And in this case, one individual was found working illegally at Turquoise Horsham. We acted upon intelligence that illegal workers were employed at the premises. Full details of this individual are contained in the review pack. Turquoise officially opened for business during the week of the 1st of October 2024, and within 3 months we have evidenced breaches of the licensing objectives by way of an illegal worker. The worker was in the kitchen when officers arrived, and it is important to note that he entered the UK as a visitor. The entry allowed him to stay in the UK for up to 6 months for the purposes of visiting family and friends, tourism, etc. And therefore it did not give him the right to work. The visa in his passport explicitly states no work. The licence holder could have easily and quickly prevented illegal working and therefore crime and disorder by conducting the relevant right to work checks. These checks are incumbent on all employers. They take a few minutes to conduct. They're free of charge, and there is ample support and guidance online. In this case, the worker would have failed at the very first step. In practical terms, the licence holder would have known by looking at his passport. Should these checks have been conducted, the licence holder would have also avoided the civil penalty. Under Section 15 of the Immigration, Asylum and Nationality Act 2006, an employer could face a civil penalty if they are found to have employed an illegal worker. A £40,000 civil penalty was issued. Part of the process required the premises to return an information request. On that response, they self-identified Weybridge Temple Limited, company number 155855521, as the limited company associated with the premises. The licence holder was a director on this company previously. There was then a proposal to strike off the company, but this was objected to by the Home Office on the 24th of June 2025, and the civil penalty remains unpaid. It is also pertinent to note that the Home Office has also applied for a premises licence review of a sister branch of the Turquoise chain, where 3 illegal workers were discovered. We understand that you must look at this case on its own merits. However, our concerns with this licence holder regarding illegal working go beyond this particular premises. The licence holder also holds directorship in 14 other companies, several of which are in the food sector. We would have expected a seasoned director to have robust procedures in place to prevent illegal working and therefore crime and disorder. The Section 182 guidance at 11.27 and 11.28 summarises that immigration offences are particularly serious, and a committee should consider revocation even in the first instance. All of that being said, we recognise that our role is to bring these concerns to your attention as the local licensing authority. This is your area, it's you that answers to the electorate and represents the interests of local people. And unless I can answer any specific questions, I don't propose to take any more of your time, and I thank you for your attention and considerations.
Thank you very much for that detailed report. Thank you. Yes. We're now just to go through and make sure everyone's had an opportunity to ask any questions from that report. Thank you. So can I just go first to the licensing officers? Do you have any questions that you'd like to raise? Thank you.
No, I don't.
Does the legal advisor or the premises holder have any questions they'd like to raise? Thank you.
Yes, I would if with your permission, Chair. The first point I'd like to ask, you've in your pack, you say that all employers are duty bound by law to conduct right to work checks. Is that correct?
Unless they are self-employed, yes.
Can you point us to the actual piece of legislation that says all employers are duty bound by law? Because it's my information that there is no legal responsibility on any employer to carry out the checks, but such checks would offer a due diligence defence to a civil penalty notice if they were not conducted.
The information we rely on, it's actually detailed quite extensively in the Employer's Guide to Right to Work. It's the guidance that's issued to employers to ensure that they have a statutory excuse against liability for a civil penalty.
Yeah, and that's my understanding. There is guidance issued by immigration to say that checks should be made in order to provide a due diligence defence, but there is no actual legal, in law, there's no legal requirement for an employer to carry out those checks. That's the reason, Chair, that I'm asking this specifically is that I'm going to be proposing something to you and your committee during my presentation, and I just want that point clarified. It is something that I've clarified at previous hearings, and there is, in my submission, there's no actual offence of failing to do the checks. It's just that if you fail to do the checks, you will not have a statutory excuse as per guidance, not law. I wonder whether you could just clarify that for us, please, Alex.
Illegal working is work undertaken without legal permission to work in the UK by reason of their immigration status.
We know there are specific offences of employing somebody that doesn't have a legal right. There's also an offence for a worker to work that doesn't have a legal right. But I'm just trying to sort of iron out, and I won't push it anymore, other than there is no offence specific act and section that requires an employer to carry out these checks.
Unless the Home Office, I think they've given their answer. Unless you want to say anything else, then I think we'll move on from that point.
Only that I'm here to present the facts to the subcommittee.
Thank you, and I think you'll get an opportunity to explain that further.
Right, yeah, thank you.
Thank you. Did you have any other questions that you'd like to raise?
Just one more question. You've just told the licensing subcommittee that a sister premises is the subject of further action. That is news to my client. I appreciate that this matter will be dealt with independently, but I wonder whether it would be pertinent just to sort of highlight, to give my client a clue at this stage or not.
I think they've made their case. I don't think it's appropriate to go any further unless you specifically wanted to say something else from the Home Office.
I don't wish to make any further comment on that at this point.
Thank you.
Yeah, as we've discussed already, we're looking at this premises on its own merits, and so therefore, obviously the Home Office has presented that information, but we will be looking at the particular premises that is being reviewed today, and the particular premises licence that's being reviewed today.
Thank you.
Okay, to the committee, do you have any questions that you'd like to ask of the Home Office following that report? Thank you.
Yeah, if I could, please, Chair. I'd like to ask the Home Office representative about they investigated because of intelligence they had received, in reference to employment practices. How much intelligence was there to for you to understand that you needed to go in and make a visit to them?
I'm unable to comment or speculate about the intelligence. The visit was carried out in accordance with our processes, and the evidence found on the day is what matters for the licensing objective. I can't go into operational details about the intelligence. My role here is just simply to present the factual findings from the enforcement visit and explain their relevance to crime and disorder.
Okay, thank you very much.
Yeah, agreed.
Councillor Livingston, did you have any other questions?
Not at this time.
Councillor Trollope?
Oh, good. Yeah, could I ask our legal advisor just to comment on the points raised by the defendant concerning the legality, the requirement to do the check versus being
That's actually beyond. That's actually beyond. Yeah, sorry. That's beyond the remit of the licensing subcommittee today. The Home Office have presented evidence of an illegal worker being at the premises, and as the representative for Mr Mutley has presented already, that it's a defence, a due diligence defence, and obviously the checks are in the guidance and are expected to be followed. If you don't carry out the checks, obviously you don't have a defence if an illegal worker is found on your premises, but beyond that it's not within our scope and remit to comment further on that. We need to look at the information in the pack and presented today.
I have a quick question, if that's okay for the Home Office. Prior to the intelligence and the visit, were there any warnings or guidance given prior to that visit?
Can you clarify what you mean by warnings or guidance? Do you mean directly to the employer before we visited, or I'm not quite sure?
Before your intelligence visit, was any additional guidance provided at previous visits, or was this your first visit?
This is the first visit to the premises.
And just to confirm, I know that the civil penalty was issued to Weybridge Temple Limited. Does that penalty still remain unpaid?
It still remains unpaid, yes.
Thank you. Any other questions? I think you mentioned previously that it was issued to Weybridge Temple at their request. Was that correct? Is it unusual that it is issued to a particular company like that?
No, it's not unusual at all. The manager came forward. Her name was Derriere. Just bear with me a moment. Came forward and identified herself as the person who hired the illegal worker, and that was where it was also identified that there was that link to the limited company name, which is why the civil penalty was issued to that limited company.
Thank you very much. Do you want to make sure everyone's had a full opportunity to ask questions before we move on from that case? Are we okay to move on? Everybody? Agreed? Okay, thank you. If we now move on to the licence holder report. Sorry, we jumped a little bit early previously. I'll give you the opportunity to speak fully now. Thank you.
Yeah, thank you, Chair, and fully understood. I would like to start off by offering an apology on behalf of Mr Mutley. This whole situation is one he's not proud of. He'd like to apologise to everybody concerned. It's something that should never have happened. I'll explain shortly how it came about that it did happen, but he would like to express his sincere apologies for this situation that everyone finds themselves in. I'd like to start on behalf of Mr Mutley, the purpose of a review. The purpose of the review hearing is for the licensing subcommittee to establish whether or not the licensing objectives are being promoted. They are, and if not, if you don't think they're being promoted, what measures or what sanctions are appropriate to ensure the licensing objectives are promoted moving forwards. I would remind you that the purpose of a review hearing is not to determine guilt or otherwise. The determination of guilt or otherwise is a matter for the courts of law, not a matter for the licensing subcommittee. The purpose of a review is not for you to impose punishment. That is also a matter for the courts. As I've already stated, the review is to establish the promotion of the licensing objectives. And at paragraph 11.25 of the section 182 guidance, that actually states that reviews are part of the regulatory process introduced by the Licensing Act. They are not part of criminal law and procedure. I just wanted to set the scene there. Turquoise Restaurant is a restaurant located in Peers Place in Horsham. And as the report correctly states, the premises licence holder is Turquoise Horsham Limited. And the sole director of that company is Mr. Mutlu. Mr. Mutlu also became the DPS, the designated premises supervisor, of these premises on the same day that his company became the premises licence holder. The restaurant has a total of 100 covers. It's a ground floor restaurant. They employ up to 9 members of staff. Whilst the premises licence holder is Turquoise Horsham Limited, the premises have been operated by another company called Weybridge Temple Limited. Mr. Mutlu, as you've heard from your officer, he was once a director of Weybridge Temple Limited, but he resigned his directorship from this company on the 25th of September 2024. The date is significant in terms of this application for a review. On that date, the 25th of September 2024, Derya Erdogan was appointed as director of Weybridge Temple Limited. That appointment took place the same day Mr. Mutlu resigned. Derya Erdogan became the manager of the restaurant from this date, but Mr. Mutlu retained his position as the designated premises supervisor, the intention for the time being, because the intention was for Derya Erdogan to make an application for her own personal licence. Once she received her personal licence, there would then be an application to transfer the premises licence from Turquoise Horsham Limited to Weybridge Temple Limited. And at the same time of that transfer application, an application would have been made to appoint Derya Erdogan as the designated premises supervisor. That never happened. The intention was for that to happen. That never happened. And the reason that didn't happen is that Derya was sort of stalling on taking her personal licence qualification, which she would have needed in order to make an application for a personal licence. Yes, the transfer could have taken place before the DPS change, but it's more common and more accepted in practice in licensing parlance that a transfer and a change of DPS are often submitted in tandem with each other at the same time. Mr. Mutlu fully accepts that as the DPS, he is responsible for overseeing the general running of the premises. He's never shirked from that responsibility. As the manager of the premises, Derya Erdogan was advised by Mr. Mutlu as to the requirements under the Licensing Act, the premises licence conditions, and also in respect of carrying out checks to make sure any employees are entitled to work. His instructions to Derya were verbal. They were not documented. These instructions amount to a due diligence. Mr. Mutlu, after giving these instructions, now expects Derya to carry out the work as per his instructions. But of course, as these instructions were verbal and not documented, Mr. Mutlu is not able to prove that those instructions were given. This has highlighted the importance of giving instructions in writing and maintaining copies of said documents. If I can turn to the application for the review. The review application has been made by the Immigration Service, and you will be aware that when a review application is made, other authorities, other interested persons are invited to make their own representations if they have any concerns about the management or the way the operation of these premises. Other representations are usually made if the subject premises have caused any other concerns to any of the authorities or local people. On this occasion, in respect of this application, you've heard that there are 2 additional representations, one from Sussex Police and one from Horsham Den Neighbourhood Council. whilst both of those representations support the review application, neither representation provides any narrative or any concerns that they have themselves in respect of the operation of these premises. Those representations are simply piggybacking on the back of the information that the Immigration Service have provided. What would be interesting to know, of course, but although it's not documented, is whether the police or whether Horsham Den Neighbourhood Council have any specific concerns of their own. I could only conclude that as they haven't listed any concerns of their own within their written submissions, then no concerns exist. Also within your report is a copy of the Licensing Authority Licensing Compliance Inspection Sheet. The inspection sheet shows compliance with existing licensing requirements, with a glitch, a small glitch, I think it's fair to say, over the display of either Part A or Part B of the premises licence as required. You will, of course, note that there is no representation from the licensing authority in respect of this application. I feel sure that had there been any breaches of the licence conditions when they were subject to that inspection, that the licensing authority would have submitted a representation in their own right as a responsible authority. So what you're looking at today is an application for a review made as a result of an immigration visit carried out on the 31st of January this year. That visit resulted in one person working when there was no permission to work. The details within the immigration papers outlining the details of that visit are not contested by Mr. Mutlu. It happened. It happened. It is accepted by Mr. Mutlu that the individual concerned should not have been working. Right to work checks should have been evidenced, and advice to management regarding the checks should also be evidenced. If I can draw your attention to page 43 of your report, the page is entitled Reasons for Review. It's the Home Office Immigration Reasons for Review. In the 6th paragraph, this is the part where they state that employers are duty bound by law to conduct these checks. You've heard the previous questions and answers given. I won't delve in that respect. The reason why I needed to point that out is because I will shortly be proposing further measures to you as an alternative to revocation, measures which we believe will promote the licensing objectives moving forwards. This page also states that Mr. Mutlu is a director of 14 other businesses and has extensive experience of working in this sector. This is correct. He has held a personal licence for over 20 years. He has operated many restaurants over the years, and he understands his responsibilities. I can say in all of those years, this is the first time that any of his premises has been the subject to a review application. As I stated previously, he had instructed his manager, Deria, to carry out right to work checks, and his error here is failing to put that instruction in writing. Taking the word of the manager was clearly not good enough. The checks needed to be more thorough. The reasons for the review also go on to state that a civil penalty notice was issued to the employer, Weybridge Temple Limited. It was not issued to the premises licence holder, Turquoise Horsham Limited. I earlier stated that Mr. Mutlu resigned his directorship from Weybridge Temple Limited in September 2024, 3 to 4 months prior to this immigration visit, although he did maintain his position as the designated premises supervisor. Mr. Mutlu is not liable for the civil penalty notice. Liability is on Weybridge Temple Limited. They were the employer at the time, and you've heard the representative from the Home Office confirm that. If I can turn to the guidance, the section 182 guidance in respect of illegal working, there is a paragraph which has been highlighted by your officer, which quotes point 11.27, where illegal working should be treated particularly seriously. That's the words in the guidance, should be treated particularly seriously. And at point 11.28 of the same guidance states that it is expected that revocation of the licence, even in the first instance, should be seriously considered. Key words, should. And you will undoubtedly seriously consider that. But it does not say you must revoke the licence. It says that you should give consideration to revocation. And the reason I say that is because at paragraph 2.6 of the section 182 guidance, it states that there are certain conditions which could be appended to licences in respect of illegal working. Licence conditions that are considered appropriate for the prevention of illegal working in licensed premises might include requiring a premises licence holder to undertake right to work checks on all staff employed at the licensed premises, or requiring the evidence of a right to work check, either physical or digital, for example, a copy of any document checked as part of a right to work check or a clear copy of the online right to work check, are retained at licensed premises. So the guidance is not directing you to revoke this licence. They're actually giving you examples of possible appropriate conditions for circumstances which we submit are before you this morning. Page 45 of your report provides details of the outcome.
So can I just interrupt slightly? That guidance, as far as I'm aware, relates to applications for licences and the conditions that can be imposed in relation to the grant of a licence.
Yeah, I believe they work both ways. They work both ways. There's the potential for those. If it's in the guidance as a potential for right to work issues, then we can see no reason why those conditions couldn't be appended even following a review application. Because I think the key words in the review, in the section 182 guidance of paragraphs 11.27 and 2.8 are this word should. It doesn't say must, it says should.
Thank you. Noted. One of the options obviously available to the committee is to introduce new licence conditions, and obviously that is suggested wording, but just to clarify, the suggested wording there is in relation to the grant of a new licence, but we'll take that on board. Thank you.
Page 45 provides details of the outcome sought by the Immigration Service. They want the licence to be revoked. The second last paragraph on that page states from the Immigration Service that merely remedying the situation, for instance by imposing additional conditions, is insufficient to act as a deterrent. That's their opinion. We disagree. The Immigration Service seem to have a blanket approach in their review applications, and they always seem to seek revocation with little or no regard to individual circumstances or any mitigating factors. Individual circumstances are all different, and you even include that on paragraph 4.1 on page 7 of your own statement of licensing policy, where it states that the general principle is to consider applications on their own individual merits. We would argue that there are mitigating factors in respect of this case today that should be considered when you determine appropriate sanctions, and that you should not just revoke the licence as requested by the Immigration Service. Clearly, since the visit and since the application for review, the premises licence holder has not sat back and done nothing. He recognises that things need to be evidenced at his premises, and he needs to put things in place to ensure that he is fully compliant with the rules and regulations whilst employing people at the restaurant. He has sought advice. He has now made sure that his staff employment records are up to date. he has made sure that his staff employment records are up to date and accurate, that appropriate due diligence sheets are maintained, and any subsequent checks that need to be made are diarised. Copies of the records which are now maintained were forwarded and are part of your bundle. And I'll just comment on the previous question from the councillor here. The visit on the 31st of January, there's then the licence holder is unaware of any actions that are likely to be taken or the reasons why. It's normally only when an application for a review is submitted that focuses the mind, and the due diligence kicks in harder to make sure that they are fully compliant, hence being done rather later than from the first visit or from the only visit in January. It may seem that action was only taken as a result of the enforcement action and the subsequent application to review the premises licence after the horse has bolted, so to speak. But this is a case, in these circumstances, physical right to work checks were carried out prior to the immigration visit, but they'd not been documented. For these reasons, we believe the appropriate response in respect of this application today is for you to append conditions to the premises licence. We take issue with the claim from immigration that conditions being appended are insufficient as claimed, or in fact, they sometimes suggest they are purely a duplication of law. Conditions on a premises licence carry severe consequences. Failing to comply with conditions can lead to an unlimited fine. It can lead to 6 months imprisonment. It could lead to both. This has the effect of focusing the mind on any premises licence holder. It is, of course, for you to decide which sanction, if any, to impose on the premises licence holder as a result of the review application. On page 16 of your report, you are provided with the possible sanctions for consideration once you have considered the evidence before you. In the circumstances before you today, Mr. Mutlu accepts that he should not have just taken the word of his manager to confirm that the correct checks were carried out. He accepts that he should have documented his instructions to the manager. He therefore accepts that sanctions are likely to be imposed. I ask you to pay particular attention to the guidance of paragraph 11.20 that advises that the sanctions imposed should always be no more than an appropriate and proportionate response to address the causes of concern that instigated the review in the first place. We therefore believe that the most appropriate and proportionate sanctions in this case are to modify the conditions of the premises licence, which will ensure that proper and robust checks are made in respect of employees and that proper and robust records are maintained. We would therefore propose 4 additional conditions to be appended to the premises licence. The first proposed condition, that the premises licence holder will operate a full human resources management system where all relevant documents to prove entitlement to work are stored for each individual member of staff. I would point out this is not a duplication of law. It is over and above what is required, and such records can be shown and produced to the authorities upon demand. So a full first condition, a full HR management system. The second proposed condition is that all copies of relevant documents from members of staff will be retained for a period of 24 months post termination of employment and will be made available to police, immigration or licensing officers upon request. Again, this is not a legal requirement, but the licence holder will be in a position to show such records for all members of staff in the event of a future visit. And let's be honest, there is likely to be future visits. The third proposed condition is that the premises licence holder will work with an immigration compliance business to carry out checks on the Home Office website and to verify identification documents such as right to work to ensure that all new members of staff can be legally employed. An independent immigration compliance business to work with and to ensure checks are carried out. And the fourth proposed condition, no new member of staff will be able to work at the premises unless they have provided satisfactory proof of identification and right to work, and this to include any work undertaken on a trial period or a part-time basis. Again, Chair, this is not a legal requirement, it is advisory only. By conditioning this, it affords consequences if it's not complied with. You may also consider removing the designated premises supervisor from these premises, removing Mr. Mutlow, and Mr. Mutlow to provide a more, maybe a member of staff that works at the premises more often in order to be the DPS, a more hands-on approach as the DPS. Mr. Mutlow, he is a manager, he has a lot of experience, he's been the DPS at many other premises, but he's quite happy to step down and have another DPS appointed in order, another layer of supervision, if you like, another layer to ensure that checks and conditions are being complied with. So the premises licence holder, I'm almost there, Chair, has not sat back as a result of this application. He knows he needs to get things right. He has already taken appropriate steps to ensure he complies with the proper requirements, and this is evidenced in the additional information which I forwarded last week. The imposition of these conditions, as suggested, will ensure that the measures he has already taken are continued throughout the life of the business. There is no room for complacency, as not complying with the conditions on a premises licence has consequences in its own right. It is our submission, Chair, that the imposition of the proposed conditions is an appropriate and a proportionate response to the reasons for the review application. They address the causes of concern that instigated the review. Imposing these conditions in our respectful submission is appropriate and proportionate, exactly how the Licensing Act, through the advice within the Section 182 guidance, was intended. I apologise for the length, but I think this is very important, and thank you for listening.
Thank you. No, thank you very much for that detailed report. There was a lot there, but first of all, I'd like to acknowledge your opening statement on behalf of Mr. Mutlow to give the apology. That was duly noted. Thank you. And also your conclusion with the 4 proposed conditions. So thank you and duly noted. Thank you. I'm going to move over to questions from our licensing officers. First of all, I think there was one question that was actually raised by the licence holder representative there, was that were any other issues noted at Turquoise Restaurant in the past? And then I'll get you to answer your own questions. Thank you.
It's as per my report, obviously the Part B not being on display for the public, and also the immediate not awareness of the licensing objectives. They were my only major concerns.
I think there was training record as well, wasn't there? In Part B?
Yes,
Yep.
the records were deficient.
Do you have any specific questions that you'd like to raise?
No, that I need to.
Do you have any questions that you'd like to raise?
Okay, regardless of who made the hiring decision, the licence holder remains accountable for what happens on the premises. The Licensing Act places the responsibility squarely on the premises licence holder and DPS to ensure lawful and compliant employment practices, compliant employment practices on site. Even a single instance of illegal working is a criminal offence, and licensing is forward-looking. The risk to the crime objective is what matters here. My focus is to present factual evidence, particularly in relation to illegal working, linked to the crime and disorder licensing objective. Thank you.
Thank you. Councillors, would you like to raise any questions? Councillor Livingston?
I have no further questions this time.
Councillor Trollope?
No questions, thank you.
Any further questions?
Can I just ask one question? You have sent through some right to work checks that have been carried out. I think they were submitted to us on the 8th of November in relation to current employees, is that right? And the dates of those checks are all, they all appear to be early November, so a few days before they were submitted to us. So can I ask, if they're in relation to current employees, were those checks submitted retrospectively? I.e., were the employers already working at the premises when those checks were carried out?
Yes.
Thank you for clarifying.
Very simple point, I suppose I have. It's just I'd almost like you to walk me through how somebody might be employed at Turquoise. We see on, I think it's section 3.7, it says that Deria Erdogan confirmed initially that she had conducted the right to work checks on the worker by viewing their work permit, but had not verified his immigration status before commencing work, and was unaware that it was not able to hold the right to work. Do you just want to talk me through that, and perhaps the Home Office can perhaps clarify how that would be possible, you know, defining the work permit versus the immigration status, and how it come about that they could be employed without that check? Thank you.
It's my understanding, and I'm sure I'll be corrected myself if I've got this wrong, but the responsibility for employing the staff was down to Deria Erdogan as the manager of the premises. Mr. Mutlow advised she must carry out proper right to work checks. That instruction was given verbally, but what Mr. Mutlow didn't then do is check that she had done it properly. She clearly hadn't done it properly, which is why she employed this person without actually having those documents. This whole episode has highlighted the importance of putting all of these checks in writing, putting everything, documenting absolutely everything and date stamping. But that was never done in respect of the employee found at the time of the immigration visit.
Though she was an experienced manager who had been working for. Thank you. I just want to make sure everyone's had an opportunity to ask any questions that they have. One further question from the Home Office.
I just need to add to that. She admitted that she had not checked his immigration status before offering him a job. Just wanted to make that clear.
Thank you. Noted very much. Thank you. Okay, we'll move back. Now I think we're on agenda item number 6, which is the closing statements, just to have everybody have an opportunity for each party to make a closing statement. First of all, we'll go to the licensing officers. Thank you.
So the committee will apply weight as appropriate today to the points that have been raised, and although conditions have been put forward, these are not to duplicate other statutory provisions. This is outlined in 1.19 of the Section 182 guidance. It also goes on to say that licensees should be mindful of their requirements and responsibilities placed on them by other legislation, which also mentions the Immigration Act 2016. No, that's it. Thank you.
Thank you.
Thank you very much. And move over to the Home Office, please. Thank you.
The Home Office does not wish to be involved in unnecessarily restricting genuine community services such as successful pubs, restaurants or shops. However, there are concerns over the way this business was being run, as discussed, and there needs to be some remedy to that behaviour and a significant way of ensuring that it will not be repeated. This should also serve as a clear message to other businesses who are fully compliant with relevant legislation that satisfactory action has been taken. As described, given that one illegal worker was found on the premises, this has been sufficient for the Home Office to issue a civil penalty of £40,000, and this still remains unpaid. From what was discussed, it is clear that the new licence holder had not conducted the relevant checks of the business. We have no confidence that the licence holder would be able to uphold the licensing objectives in the future. Therefore, the licence, we feel, should be revoked.
Thank you. And final closing statements, please.
Yes, thank you, Chair. It's interesting that we've just heard that immigration have concerns about the management of the premises, but there's only been one visit and there was one worker found. There's no evidence of any other concerns about the management or operation of these premises, nor, it would appear, are there any concerns from any of the other responsible authorities about the management or the operation of these premises, even though there are those two additional representations, as I said earlier, piggybacking on the application, not providing any new information, and with, of course, the visit from the licensing authority, some what I would class as minors.
I'm going to interrupt for 1 second.
Yes.
Apologies for interrupting you. Obviously, we can't. I agree with you. There is no narrative in the representations that have been made, but obviously we can't speculate as to the intention of the responsible authority and the interested party in those reps.
Am I allowed to surmise though?
Obviously you can surmise, but obviously the subcommittee will can't speculate as to what the reps, the intention of the parties making the reps was. They can only look at the representation that's been made.
Yeah, and I fully accept that. And had they been present today, I would have asked. Okay. Immigration also state that illegal working is a criminal offence. We know that, but according to our knowledge, there's been no prosecutions of any offences in respect of illegal working. I should have pointed out earlier that the manager, Deria, no longer works at the premises. She has moved on. Full responsibility is reverted to Mr. Mutlow. Mr. Mutlow has employed a new manager and will train that new manager in accordance with the terms of the licence. And the one final comment from the comment made by licensing that proposed conditions should not be duplicated in law. I would respectfully suggest that the 4 proposed measures during my presentation are not duplicitous in law, but they are over and above what is required in law, hence suggesting them as possible sanctions or possible new conditions to be appended to the licence. And yeah, that's about everything I needed to say. Thank you, Chair.
Thank you very much. Do our legal advisors have any points to clarify?
No, thank you.
Okay, so agenda item number 8 is when we will go into deliberation. We will withdraw to our subcommittee room and be accompanied with our legal advice to discuss and to come back hopefully with a decision for you. I expect we're going to need at least 45 minutes an hour.
Okay.
Yep, that's right.
So,
Okay.
12:20, are we?
We'll let you,
Can we say 12:30?
12:30.
Yeah. Okay. So.
and we'll let you know if that changes, but we'll meet back at 12:30. Thank you very much. I'll call this part of the meeting to a close. Thank you. Okay, thank you. I think we're all back. We're back on live stream, so thank you very much. So we finished our deliberations, which was number 8 on our agenda, and apologies for the delay. We've taken time to consider all our options. I'm now going to read our report decision. Just move this in. The subcommittee has been asked to consider an application for review of a premises licence at Turquoise 4 Perry's Place, Horsham, West Sussex, RH12 1EH. The premises licence is held by Turquoise Horsham Limited, a private limited company with one director, Sevet Mutlu, who is also the designated premises supervisor, DPS. The review of the premises licence has been sought by a responsible authority, the Home Office, Immigration Enforcement Licensing Compliance Team, under Section 51 of the Licensing Act 2003. The application for review relates to the licensing objective for the prevention of crime and disorder. The subcommittee listened carefully to the representations from the applicant, the premise licence holder's agent, and the licensing officers, and also considered representations from a responsible authority and an interested party. Each member of the subcommittee has also carefully considered the report put forward by the licensing officer. The subcommittee noted that Sussex Police and Horsham Den Neighbourhood Council both supported the review application and the applicant's request that the premises licence is revoked. The decision of the subcommittee is made in consideration of the Licensing Act 2003, the Secretary of State guidance issued under Section 182 of the Licensing Act 2003, and the Equalities Act 2010, the Human Rights Act 1998, and Horsham District Council Statement of Licensing Policy. In reaching its decision, the subcommittee sought, as far as possible, to establish the cause or causes of the concerns that the representations identified. The decision of the subcommittee is to revoke the premises licence. The subcommittee believed that the illegal working evidenced by the applicant was associated with the premises, and as such, the licensing objective of the prevention of crime and disorder was not being promoted and upheld at the premises, and that, on balance, the premises licence holder cannot satisfactorily uphold the licensing objective through continuation of licensable activities at the premises. The subcommittee considered at length other options available to it under the Licensing Act 2003, but believed that these would not be adequately promote the licensing objective of the prevention of crime and disorder. Revocation of the premise licence was considered by the subcommittee to be an appropriate and proportionate response to address the cause of concern that instigated the review. There is a right to appeal this subcommittee's decision through an appeal to the Magistrates' Court. The rights are set out in the Licensing Act 2003, and parties are reminded that an appeal must be commenced within 21 days of notification of the decision to a relevant party. The subcommittee's decision will come into effect when the period given to the appealing agent, the decision, has been passed, or should the decision be appealed against once the appeal is disposed of. A full decision notice with reasons for the subcommittee's determination will be provided within 5 working days of this hearing. Thank you. I think the only other thing on the agenda was item number 5, urgent business, which I believe there was none. So at 1:31, I close this meeting. Thank you very much.